Oh, good. Somebody typed into me. Thank you. I appreciate that. I hear you. Great. And can you see the PowerPoint presentation on the screen? Great. Okay. Here we go. So what I'm going to do is I'm going to go through this PowerPoint presentation. If you have questions, feel free to send them to me, but I may get bombarded with them. But I would ask that you limit your questions to the topic that I'm discussing at the time, and then I'll try and field any other questions. We only have an hour. If you have specific questions about, say, for example, your company's policies, current policies in place, whether or not you fall under the safe harbor provision, I would prefer it if we maybe discuss this offline. And I'd be happy to field questions either on the telephone or you can send me an email. And you will have all my contact information at the end of the PowerPoint presentation. So to start, oh, and something else, I understand that I'm speaking to contractors, roofing contractors who are both, who may be both signatory to the Roofers Collective Bargaining Agreement and open shop companies. That's my understanding. What I want to make very clear is that the earned sick time law that goes into effect this Wednesday, July 1st, applies to all employers. These are your statutory obligations under state law. That's what the earned sick time law is and the Attorney General's regulations are. It applies to everyone. In addition, however, if you are signatory to a collective bargaining agreement, you may have additional contractual obligations, and that when we get to what the regular rate of pay is, that is when it may come up. So going to first slide that you should all be seeing is that when does the sick time law go into effect? This Wednesday, July 1st. There is a safe harbor provision, which I will get to in a little bit. If you currently have a sort of either a sick time policy or a paid time off policy in effect right now or as of May 1st of 2015, you will fall within the safe harbor provision. What that means is that the Attorney General will consider you to be in compliance with this law regardless of what your current policy is, as long as it meets some certain basic elements, such as that you already give people up to 30 hours time off during this year. And if you do fall within the safe harbor provision, you will be considered to be in compliance. However, you still need to, any employees that you have, say your hour employees who are not entitled to time off up until this point, they need to start being able to accrue and using whatever your time off at your current policy. So your policy may need to be changed as of January 1st of 2016, but for purposes of Attorney General enforcement, you're fine as long as you give or allow to accrue and use to your employees those who up until this point had not fallen within the time off policy. Okay, so moving on, what can sick time be used for? An employee who has earned sick time and wants to use it can use it for limited purposes. This is very different than having a paid time off or vacation policy in which that employee could use it for, quite frankly, whatever they want. Earned sick time can only be used to take care of yourself, your spouse, your child, your parent, or the parent of your spouse. And that time can be used for bringing somebody to an appointment, traveling to and from medical appointments. They can be for either physical or mental illness, for injury or medical conditions that either require home care or bringing either the employee or the employee's family member to a medical professional. This can be for preventative care, routine visit, or emergency visit, or specialist visit. It's just meant to be for some kind of medical or physical condition or illness. In addition, what can sick time be used for? It can be used to address any psychological, physical, or legal effects of domestic violence. We'll get into more on domestic violence in a little bit. Please note, however, that sick time cannot be used to call in sick because you're late, because you ran into traffic. It cannot be used as an excuse for tardiness per se. Obviously, somebody can come into work late because they are sick, but it cannot be used to go to the beach, go out to lunch, that sort of thing. It's supposed to be used for sick time purposes. If anyone has any questions as to what sick time can be used for at this point, please send it in. Otherwise, I'll move on to the next slide. Okay, so no questions so far. Who is entitled to sick time? Well, that is going to be all employees who do work in Massachusetts. And what does that mean? It doesn't matter where the employee lives, as long as his or her primary workplace is the Commonwealth of Massachusetts, then he or she is entitled to earn and use sick time. It doesn't matter where the employer is. There are many employers whose businesses are outside the Commonwealth of Massachusetts. For example, Walmart, you could say is. But in the world of construction, we have lots of construction companies that are housed either in Rhode Island or New Hampshire or Connecticut and do business in the Commonwealth. What is centrally important is that it's where the employee's primary place of work is, and that's where you're going to have a problem. Because the way that the regulations look at what a primary place of work is, it doesn't matter if the employee has worked more than 51% or 50% of their time in the Commonwealth, as long as they don't have to meet that 51% threshold. All they need to do is have their primary place of work in the Commonwealth. For example, in the Attorney General's regulations, she uses an example. Oh, I see I have a question. Let me just finish off this piece and I'll go back to the question. A painter with a single employer works 40% of her hours in Mass, 30% in New Hampshire, and 30% in other states. In that example, Massachusetts is her primary place of work. So what that means for you as an employer is that you now have to track not only someone's hours worked, but the location of where those hours are being worked, which can be very, very difficult. And then you need to determine whether or not each employee's primary place of work is Massachusetts. Obviously, if you only perform work within the Commonwealth, it's easy. But if you perform work in more than one state, this becomes far more problematic. Please note that it's well, let me go back to this other thing in terms of which employees. So number one, their primary place of work needs to be the Commonwealth. In addition, it doesn't matter how many hours that employee has worked, if they're full-time, part-time, seasonal, or temporary, if they're salaried or hourly employees, they're all entitled to earn and use sick time. There are some exemptions, at which place I didn't think that this would come into place for the most part when it came to the construction industry, but actually it has come up. Under the definition of employee, federal employees are not included in the sick time law. City and town employees are not included in the sick time law unless the town adopts the law itself, say through town meeting. But there is an exemption here that may pertain to the construction industry, and that is, and this was added by the Attorney General, an adult client who resides in Massachusetts licensed programs and performs work duties within the program setting as a part of a bona fide educational or vocational training. If you have some employees who are like that, get in touch with me directly, and I may suggest to you that you get in touch with the AG's office to see if this bona fide educational vocational training falls within the exemption status. So I'm going to go back now to the question that was asked. It was, let me see, the question is this, Lord. Can you ask the employee for a doctor's note when they say they are out sick, or is their statement that they don't feel well sufficient to meet the definition of sick? So your question is a good one, and yes, you can ask them for a note, but only after. You can only ask for verification that they were out because they were sick after the employee has missed either 24 consecutively scheduled hours of work or 3 days of shifts in a row. And I'll get more to that later when we talk about verification, but unless they fall within that category, there's some other times when you can ask for too, and I'll get to that later. But otherwise, if somebody says to you, I was in the emergency room last night, or I had to take somebody to the doctor on an emergency basis, then no, you can't ask for verification. There is notice requirements by the employee, however, and we'll get to that in a minute, that that they need to, the employees are required to give you notice if they know that they're going to be out sick. And if they don't, you can discipline them for it. But of course, if it's an emergency basis, including, they wake up in the morning, they don't feel well, then notice is no longer foreseeable, so they're not required to give it. But if they're just missing that day's work because they have a doctor's appointment or they call in sick because they don't feel well, they are not required to verify it. Okay, so now back to who is entitled to sick time. Unless there's any other questions, I'm going to move on to the next slide. At least I think I am. Okay, going back to primary place of work, I discussed it already. Employees may accrue and use earned sick time if the employee's primary place of work is Massachusetts. Here's where it need not be more than 50% of the time in Massachusetts. And here's where it becomes problematic when you have employees who work in more than one state and their primary place of work is Mass. Because if they are eligible, if their primary place of work is Massachusetts, then all of the employees' hours, including work performed outside of Massachusetts, are counted towards earned sick time, which is a real deviation from how the Attorney General normally looks at work performed outside the state. But for purposes of the earned sick time law, if your employees are considered to be working primarily in Massachusetts, then they are entitled to earn and accrue on all of their hours worked, not just the hours spent in Massachusetts. The Attorney General's regulations also state that eligible employees who are permanently transferred to another state with the same employer will no longer accrue earned sick time, but they may use accrued time that they had earned when Massachusetts was their primary place of work. If anyone has any questions as to who is entitled to use sick time or where the primary place of work is, please send it along now, or any of the topics that we've covered so far. Moving along, which employers must pay for earned sick time? Okay, so every employee is entitled to accrue and use earned sick time, but the only employees who get paid for using their sick time are those employees who work for employers whose size is 11 employees or more. Now, to determine whether or not your company fits into this category, you will have to pay for earned sick time. Number one, the Attorney General looks at the average number of employees you've had for the preceding year. And that can be a fluid number, and I get that. Sometimes employers' work is seasonal, and they may have 18 employees for a while and then drop down to 9. And there is, so in some respects, she's saying you can look on a daily basis to determine in the last preceding year whether or not you had an average of 11 or not. To determine which employees are included, to determine whether or not you have 11 or more employees and therefore must be paying for sick time. This includes, an employer's total number of employees includes full and part-time, seasonal, and temporary employees, regardless of where the employees work. So you could be a Rhode Island company, and you have employees who work in Rhode Island and Massachusetts, and those employees whose primary place of work is Massachusetts are going to be able to accrue and use sick time. Whereas your Rhode Island employees would not, because their primary place of work is not Massachusetts. In addition, one thing that should be noted is that there's an asterisk where it says temporary employees. If you use workers through a temporary agency, the Attorney General's regulations now say that those employees are going to be included in your total workforce to determine whether or not you have 11 or more employees, and they're going to be used in the temporary agency's total workforce. So they get counted twice. Not sure where the Attorney General came up with that regulation. It does seem inherently unfair because the temporary agency is truly the employer. But for purposes of whether or not you have to give earned sick time to your regular employees, you would have to include any employees or workers you use through a temp agency in your total count. That could mean, for example, if you're hiring somebody to work office help, that you work through like Kelly agency, something like that. If your employer size is going to change, the regulations state employer must provide 30-day advance written notice if your sick time changes from paid to unpaid due to this change in size of your company. which is a little unfortunate because sometimes you may not even know how quickly you're going to reduce down to fewer than 11 employees and then unpaid status. But I think as long as you try to be in compliance with the spirit of the statute, that's what the Attorney General's office is going to look for. So I have another question that came up on workforce size. Okay. Is there a website or a calculation to find out an employer's average workforce size? Well, all you can do is look at the Attorney General's regulations, and what I would strongly recommend, and I've put the link to her website at the end of the PowerPoint presentation, is that you go on to the Attorney General's website and you look at her regulations if you have not done so yet, because that's where she discusses the size of the employer. Hold on just a second, I'll see if I can find it. You know what, employer size. So if you go onto the Attorney General's website when we get off and you look at her regulations, it's very easy to find on her website. She's made it very, very clear. If you look at, under her regulations, section 33.04, number 1, an employer, she says an employer must provide earned paid sick time to all eligible employees if the employer maintained an average of 11 more employees on the payroll during the preceding benefit year. And then she states, employers shall determine the average number of employees by counting the number of employees, including full-time, part-time, seasonal, and temporary employees on the payroll during each pay period and dividing by the number of pay periods. Employees furnished to an employer by a staffing agency and paid by the staffing agency count as employees of both the staffing agency and the employer for the purposes of determining employer size. So that's how the Attorney General tells employers to figure it out. And that should answer that question. She also says if an employer uses multiple start dates for the benefit year, such as dates based on employees' anniversaries of hire, the employer should calculate the employer size based on the previous January 1 to December 31st calendar year. Now, I think there's another question. When will there be a decision made by the judge on the lawsuit to exclude unions from this law? That I don't know. Sorry for you non-union signatory contractors here, but we had oral argument on this decision on June 16th, so we were waiting for the judge. She took the matter under advisement, and we were waiting for the written decision. As soon as a decision comes out, we will send word out. Okay, so moving on, from which employers must pay for earned sick time. So, and remember, if you have fewer than 11 employees, those employees are still entitled to accrue and use sick time. You just don't have to pay them for their time off. Okay, so now, regular hourly rate of pay. The law says that the wages the employee, what you pay for sick time are the wages the employee would have been paid for the hours that he was absent. This law was designed to benefit sort of the lower wage earner who's generally their rates don't fluctuate in pay. You know, say you're a minimum wage employee. Unfortunately, when this law was passed by the voters of the Commonwealth in November, they didn't consider that there are certain workers out there who have a very, very high hourly rate of pay and that it can change. So, for example, you could be doing prevailing wage work and non-prevailing wage work within the same week. And so how do you figure out what somebody's regular rate of pay is? Well, the Attorney General says you can pay a blended rate if the employee works at more than one rate. So you can do that, sort of like you do pay for overtime, you can pay a blended rate if an employee is working at more than one hourly rate of pay during the course of that pay period. However, the regular rate of pay specifically does not include benefits, health, welfare, pension, any monies that are contributed to an employee benefit plan. In addition, and this is under state law now, in addition, the regular rate of pay does not include overtime pay, it doesn't include holiday pay, and it doesn't include premium rates. However, where the differential rate is the regular rate of pay, that differential rate is not considered a premium rate. Rather, it is considered the regular rate of pay. So there certainly can be situations in which you might have to pay a blended rate or just the regular rate, but particularly if you are a union signatory contractor, here is where you're going to come into problems. Because even though the state law says you don't pay benefits, you don't pay overtime, you don't pay holiday or premium rates, you need to look to the language of your collective bargaining agreement. Now, I can tell you that I have looked at the roofer's collective bargaining agreement, and it says that you only pay benefits on hours worked. So you would not be paying benefits. Now, that is different if you were a signatory to a different collective bargaining agreement. For example, operating engineers, locals 4 and 98, and iron workers, local 7, they all require benefits to be paid on every payroll hour. So in that case, we're telling contractors they need to pay benefits when they pay sick pay. But under the roofers collective bargaining agreement, similar to the carpenters and the laborers, it says that benefits are only paid for hours worked. So I would suggest to you that you only need to pay the wages. However, for sick time, that's the regular rate of pay, no benefits. However, you would need to see if there's premium rates paid. For example, if somebody is scheduled to work on a Saturday or a Sunday, and the regular rate of pay would either be time and a half or double time, I would suggest to you that if somebody was scheduled to work on a Sunday, not because they were working overtime, but because they were scheduled on a Sunday, and if your collective bargaining agreement states you have to pay either time and a half or double time for Sunday pay, I would suggest to you that is the regular rate of pay. People argue it, and there will be contractors who will not pay it. They'll just pay straight time only. But I think you are looking at a potential enforcement action, maybe not by the Attorney General's office, but you could certainly have a grievance filed against you by the employee. And then there's also the private rights of action, which are even more problematic. In addition, when do you pay sick time? With the regular wages. So whatever your pay period is, and if the sick time fell within that, then you put the sick pay into the next paycheck. I see a question's come in. Let me just see what it is. Okay. Okay. The question is this: if we already offer paid time off that can be used for sick time, vacation time, personal time off, and it meets the accrual rate that the AG specifies, will this qualify, or does it have to be a specific sick time policy? No, you are allowed to use a substitute policy. You can call it whatever you want, and so as long as you allow the employees to accrue at the rate that the Attorney General or the law requires, which we haven't even gotten to yet, and as long as you allow your employees to use this time off, whatever you call it, for the same purposes and with the same job protection that the sick time law allows, then you're fine. That's your substitute policy. I will tell you one of the things that sick time law does not require, that say if you had a vacation policy would, is that if you have an employee who has accrued time and hasn't used it and separates from employment, you do not have to pay that employee unearned sick hours. You do not have to pay that. That is very different from the vacation policy. Vacation policies fall under the Massachusetts Wage Act, and it specifically said that vacation time is wages. Therefore, when an employee separates from employment, you are required as the employer to pay out any unused vacation time. Very different from the sick time law. You do not pay that out unless, of course, you want to. Okay? So moving on to how is sick time earned? So this is we're going to start talking about accrual. An employer must provide a minimum of 1 hour of earned sick time for every 30 hours worked. Those 30 hours do not need to be continuous. It doesn't matter if somebody misses days or weeks of employment. They continue to accrue as long as they're working. So if somebody is out on vacation, so you have a regular employee and somebody's out on vacation, they're not accruing sick time hours while they're on vacation. Okay, they are only accruing 1 hour for every 30 hours used while they're actually working. When do they begin accruing sick time? They begin accruing on their first date of hire. Everyone starts accruing on July 1st. And if they are hired after July 1st, they begin accruing on July 1st, whichever date is later. when do they become eligible to use it? That's a slightly different issue. So you have employees begin to accrue as of July 1st or later, depending upon the date that they get hired. However, they become eligible, depends on as 90 days after their first date of employment with your company. So if you have somebody who started working on July 1st, that person becomes eligible to use any accrued sick time 90 calendar days later, not work days, but calendar days later. If you had an employee who began working for you last year, they will be eligible to use sick time beginning July 1st, assuming they had accrued it. So whatever that employee's first date of work is, and regardless of how many days that person works for you, 90 calendar days later, they're entitled to use earned sick time. Of course, they had to have accrued it, but they're entitled to use it. By mutual written agreement, an employer may arrange for employees to use their earned sick time before it is accrued and for the employer to count the use against future accrual. So if somebody wants to, if somebody knows they're going to be out sick, for example, like they have a surgery coming up and they haven't accrued enough time yet, you could mutually agree through a written agreement to allow that person to use it sooner than it's actually been accrued and then offset it against future accrued hours. Okay, so moving on, accrual of sick time. This seems to be one of the bigger issues for people, and understandably so. So there is a 40-hour cap on using sick time per calendar or benefit year. Calendar year and benefit year mean the same thing. It just depends on what date you, the employer, decide to set it up. It could be based on the employee's work anniversary. It could be based on January 1 to December 31st. It could be based on your fiscal year. It's up to you. But all employees may use up to 40 hours of sick time per benefit year. So if they earn, they accrue, and they can use up to 40 hours and no more than 40 hours. And I want to be very clear, this law, when it went into effect, was not intended to give employees who already fall under some kind of paid time off policy, including vacation time, this law was not intended to give them another 5 days. What this law was intended to do was give people who don't get any sort of time off guarantees 5 days off so that they could take care of physical or sick time issues, whether for themselves or for a family member. So, so again, 40-hour cap. An employee is entitled to use up to 40 hours of earned sick time per benefit year. However, if they don't use it all, they are entitled to carry over up to 40 hours into the next calendar year. Once an employee accrues 40 hours of sick time for the benefit year, he does not accrue additional sick time hours regardless of the hours worked, meaning you can stop tracking it. Once he's got 40 hours in the bank, you can stop tracking that. However, if he starts whittling down to below 40, he can start accruing again. So he accrues 40 hours, he starts using 40 hours, he can start accruing again. But remember, he can only use 40 hours a year, and he can only roll over 40 hours into the next benefit year, okay? And that's it. And again, the goal of the statute is for employees to use up to 5 days a year per employer. So moving on. Breaks in service. Well, in the world of construction, we all know layoffs are inevitable, and it's a very transient workforce. And so people leave and they come back. And so the Attorney General has now adopted a series of regulations in which she addresses the issue of breaks in service, which actually it's in the regulations. Again, look at them on her website. It's not that hard. Oh, wait a minute, I have a question. Hold on, let me go back. Okay. Is it required to show time accrued on pay stub? No. This goes into the records keeping statute. So what the records keeping provisions essentially say you employers, part of your payroll records, have to keep track of the hours earned and accrued and therefore used. Now, the pay stub statute is different. It doesn't. The pay stub statute, as it states, says that you have to give a pay stub that says, besides name and address, hourly rate of pay, number of hours worked, the deductions listed, that sort of thing. It doesn't say that you have to state the hours accrued. You could transfer it over. You could put on the pay stub hours accrued and hours worked, but it's not a requirement yet on the pay stub. The pay stub statute has not been changed. In your payroll records, you need to keep track of it. And if an employee wants to see those records, you have to produce them within 5 days. So let's see. Here's another question coming in. Okay, let's see. Here's two more. Can we pay the employee for the accrued time at the end of the year? Meaning the employee hasn't left service, I assume is what you mean, and you're going to pay out the accrued time. Sure, if you want to, you can. I'm not quite sure why you would, but certainly if you want to be the nice, benevolent employer, you can do that. However, if you choose to pay them out unused accrued sick time, you are still required to, and this is a really, really weird, funky section in the law. It falls under section 33.03, number 27. And here's what it says. Employers shall have the option but are not required to pay out employees for up to 40 hours of unused earned sick time at the end of the benefit year or when the employee changes jobs within the employer's employment. Employers paying out 16 hours or more shall provide 16 hours of unpaid sick time until the employee accrues new paid sick time, which shall replace the unpaid time as it accrues. Employees paying out less than 16 hours shall provide an amount of unpaid sick time equivalent to the amount paid out until the employee accrues new paid time, which shall replace the unpaid time as it accrues. So yes, you can pay it out at the end of the benefit year if you choose to, and I would be looking back at the regulations to figure out exactly what your requirements are if you choose to do that. But remember, you do not have to do that. You can just allow them to roll over up to 40 hours into the next benefit year. Okay, does an employee accrue sick time? Okay, hold on a second. Does an employee accrue sick time? It says carry in the beginning of the new. Okay, I think I understand this question. Do they start to accrue sick time if they're carrying over 40 hours? No, they have 40 hours in the bank. They're not accruing at this point. As long as there's 40 hours in the bank, they're not accruing anything. So when they start dipping below 40 hours, that I would be concerned. And then I would start tracking their time. And remember, they only get paid up to a maximum of 40 hours per benefit year, and they can only roll over 40 hours maximum into the next benefit year. The goal here being the 5-day maximum. Okay, breaks in service. If your employee leaves your employment, and if it's up to 4 months before that employee returns, the employee may use any unused earned sick time accrued before the break in service upon his return. So he leaves you, you're a seasonal employer, for example, and employee who's earned sick time, he leaves you on December 1st, you lay him off. And then he comes back in March 1st, which is within 4 months. He's entitled to use any used accrued sick time that's sitting in his bank as soon as he returns. So that's when an employee has the break in service is up to 4 months. For any time between 4 months and 12 months, an employee may use earned sick time accrued before the break if his unused bank of earned sick time exceeds 10 hours. So as long as he's over 10 hours in the bank, he can, upon his return between 4 and 12 months, use that upon his return. If an employee has been gone for over 12 months, the employee may not use any earned sick time, meaning he forfeits those hours. If he's been gone for over a year, he forfeits the hours that he earned but didn't use. But he retains the right to use sick time earned and accrued upon his return, meaning that he comes back with, it doesn't matter he's been gone for a year, he starts accruing again and he's eligible to use immediately. He doesn't have another 90 calendar day eligibility period. And here we go. Employers may but are not required to pay out unused sick time upon the employee's departure from employment. If you want to, you can, but you don't. The law does not require it. Okay, so I'm going to move on. I don't see any additional questions. Use of sick time. Okay, so you cannot use, if you weren't scheduled to work, if an employee's not scheduled to work, he can't use unscheduled time as sick time, meaning he's not going to get paid for the time he's not scheduled to work. I mean, that just doesn't even make any sense, but I'm sure there'll be some employee who tries to do it. The smallest amount of time that an employee is allowed to use now is 1 hour. It wasn't like that initially, but the Attorney General's latest regulations, or final regulations, say you can use the smallest time allotment that an employee may use is 1 hour. So even if they're going to be 15 minutes late because they're coming back from a doctor's appointment, it's an hour, it's 1 hour. You cannot use sick time as a reason for being late for work, but somehow you're going to have to be able to prove that the employee is doing that. And employees may not accept a specific shift assignment with the intention of calling out sick for all or part of that shift. And who's kidding whom? That's your Sunday, double time pay shift. I mean, that's a classic example of it, that they're scheduled to work. Yep, I'll work on Sunday. I'm happy to do it. And then they call in sick because they think they're going to get paid double time because that's what the collective bargaining agreement requires. Now, also, where an employer is required to hire a replacement to cover the employee's use of sick time, the employer may require the employer using the sick time to use up to a full shift of sick time hours. So if you have to call in somebody, your employee doesn't want to use the full 8-hour shift, but the only way you're going to get a replacement is to bring them in for 8 hours, you can require that the employee uses all 8 hours. It means he gets paid for it, but he also has just deducted 8 hours from his bank. Okay, no questions so far. Moving on, how to track sick time. Again, 1 hour earned for sick time for 30 hours worked, or any equivalent accrual rate with smaller increments of time if you so choose to do it. Go to the Attorney General's regulations to look at the example she gives if that's how you want to do it. But by law, you need to do 1 hour earned sick time for every 30 hours worked. By mutual consent, if the employee works the equivalent number of additional hours or shifts as he took for his sick time during the same or next pay period, the employee shall not be required to use accrued sick time, and the employer is not required to pay for the time absent. So this has to be by mutual consent, though. Both employer and employee agree that if I call in sick for 4 hours, I can make it up the next day at 4 hours the next day. I'm not going to get paid for my sick time off. I'm just going to make it up on the next shift, as long as I do it within the same pay period or the following pay period. And here I see a question. The question is, how could you prove that your employee scheduled a shift with the intention of calling out sick? What a great question. I have no idea. I can't even answer that question. I mean, I suppose if you somehow got evidence that the employee was, it's a really good question. Employee calls him sick on a Sunday saying he's sick to his stomach, and then you've got, pictures of him on Facebook showing that he was at the beach that day or at an amusement park or something like that. Maybe that'd be one way of showing it. And there are penalties. You can discipline employees, which I'll get to in a minute, for committing fraud or abuse of the sick time policy. So now let's see. Another question. Long question. Okay. In our industry, there are days off due to rain. It is my understanding then that if there is no work due to rain, the employee cannot ask to use a sick day whether he is sick or not. Yes, I agree with you on that. Or has a note from a doctor stating he was sick that day. No, if he's not scheduled to work, he can't use it for sick time. The regulation's clear. Normally, it would have been a scheduled work day. I see what you're saying. Normally, it would have been scheduled, but it wasn't going to be. And I would make the argument that if it's in the collective bargaining agreement, it states it's a rain day, we cannot work. There's no work for anybody, so he doesn't get to then. And why would he should have? If he had, for example, doctor's appointment, he should have given you notice that he was going to be on that he was going to be out that day. So I would suggest to you that if he's not scheduled to work because of rain, then he doesn't get to use it as sick time. I would make that argument. And you may get challenged on it, but I would make that argument that rain means no work, therefore you cannot fill up that void with getting sick time. Okay, moving on. Notice of use of sick time. So employees must notify employers before using sick time. So there's a must. So they need to give you notice, okay, except in cases of emergency. So, and we all know emergencies come up, whether it's for the employee himself or family member, that that they can, in fact, that's the only time they don't have to give notice. For any foreseeable or planned use of sick time, the employer may have a written policy requiring up to 7 days notice, except where the employee learns the need to use the sick time within that 7 days. So you can, in fact, start imposing some policies on the notice to requiring your employees to give you 7 days notice if they've got a scheduled appointment. I mean, it seems fair. And if they fail to abide by it, you can discipline them for failure to give notice. However, reasonable notice for unforeseeable absences depends on the circumstances. So, it's just sometimes an employee is not going to be able to do it, whether it's for himself or a family member, that they are not going to be able to give you notice. And so, you're going to have to look at reasonable notice. What are the circumstances of the time? Did it seem reasonable given all the circumstances? Why or why not the employee did not give notice? For multi-day absences, the employer may require notification of the expected duration of the absence unless circumstances make notice unreasonable. For example, if you call out sick and you weren't able to give notice, and then all of a sudden it turns out you had appendicitis and you're in a hospital, well, it's reasonable for the employer to say, how many days do you think you'll be out? So when it comes to what's reasonableness in the circumstance, everything's going to be factored into it to see whether or not the employee gave you reasonable notice or not in the case of an emergency. Okay, when can an employer require documentation? We've already discussed it briefly, but this is clear. So an employer may require written documentation when the length of the earned time sick period either exceeds 24 consecutively scheduled work hours. Now remember, this is different. This isn't notice anymore. We're talking about getting documentation verifying that your employee is out for sick time related purposes. So if the time period exceeds 24 consecutively scheduled work hours, or exceeds 3 consecutive days of scheduled work, or occurs within 2 weeks prior to the employee's final scheduled day, because who's kidding whom in your world, employees can foresee when the layoffs are going to start happening. So if it's foreseeable, now this says a final scheduled day. If you know that, January 15th is going to be the last day of work for this person, and this person starts calling in sick within the last 2 weeks, then you can require documentation. In addition, for employees under 17, and quite frankly, I find this very unusual that in the world of construction we would have any employees under 17 because of the child labor laws, but in the foreseeable instance where you have an employee under 17, and if, I skipped one, sorry about that, but I'll stay with the 17-year-olds. If their absences occur after 3 unforeseeable absences within the last 3 months, if they're calling in sick 3 times and it was never foreseeable, you can then require documentation. That also goes for your regular employees who are adults. So you can require documentation when their timeout occurs after 4 unforeseeable or undocumented absences within 3 months. They're calling in sick a lot, and it seems to be frequent, and so you can demand documentation. Employers may not delay taking of sick time or delay pay on the basis that the employer has not received the documentation. So even though you demanded it, if they are continuing to stay out sick, you cannot infringe upon their rights to do so. And in addition, you may not delay paying them. Okay, you have to pay within the regular pay period. Okay, what type of documentation? Well, some sort of documentation from a healthcare provider. It can be any reasonable document signed by a healthcare provider indicating the need for sick time, but you are not allowed to demand to know the nature of the illness. And in addition, you cannot, there's only certain permissible types of documentation that can be used when it's cases of domestic violence. Those are often court documents, whether it's a restraining order, notice to appear in court, police report. That's all listed in Mass General Laws, Chapter 151A, 1G and a half, but under domestic violence is different. You as the employer may not require the employee to explain the nature of his absence, namely what's wrong with them. That's protected health information. They're not required to disclose it, and you are not entitled to ask for it. Documentation may be submitted in hand or any other reasonable method. I assume that means you can, your employees can send it electronically, is what it means. And And you may require employee to personally verify sick time usage, and that would come in the situation in which the employee has no health care and therefore no health care provider. I can't see it happening all too often, but it could. Okay, what happens if the employee does not give you the demanded documentation? Well, if you, the employer, are entitled to demand it, the employee must submit the documentation required within 7 days of taking the sick time. So as long as you, the employer, are entitled to ask for it, the employee has to give it to you within 7 days. If the employee fails to provide the documentation without reasonable justification, which is a very loose and fluid term, which will depend upon the circumstances, you, the employer, may recoup from future pay as an overpayment or may deny the future use of an equivalent number of hours of accrued sick time until documentation is provided. In addition, you may, and this is important for certain, this is important for certain things in the construction industry. Employer may require a fitness for duty certification if such certification is customarily required and consistent with the industry practice. So if you've got somebody who's been out for a while, and you can require a fitness for duty certification just to make sure that person should be put on the job site if that fitness for duty certification is sort of standard practice. Okay. Now, employee discipline. If employee is committing fraud or abuse, which is not defined under the Attorney General's regulations, she's just included it, but if the employee is committing fraud or abuse by engaging in activity that is not consistent with allowable purposes, employer may discipline. Or if the employee is exhibiting a clear pattern of taking leave, on or just before the weekends, vacations, or holiday, you may discipline unless the employee provides verification of the authorized use. So, for example, it's Patriots season, and you've got an employee who's calling in sick, every single Monday morning because the Patriots have been playing every, Sundays, the last 4 Sundays in a row, and they call in sick. Well, you can demand to see verification. If you think that's a clear pattern of behavior, you can discipline that person, and unless and until they provide you verification of the authorized use, meaning they get a doctor's note or something stating that they were in fact medically ill. So for fraud or abuse or exhibiting a clear pattern of taking leave, like, routinely, and exploiting you, the employer, then you can take discipline on your employees. Moving on, you cannot interfere with an employee's ability to take accrued earned sick time under the statute, or his attempt to assert his rights under the statute or rights on behalf of somebody else. You cannot retaliate against them for taking sick time, for asserting their rights under the statute. For example, he files a complaint for non-payment of sick time with the Attorney General's office. You can't fire them for doing that. And if you go to the Attorney General's website and you look under the Attorney General's regulations at section 33.083, you will see a list the Attorney General has provided of prohibited adverse employment actions, things you cannot do for retaliating against or for people who are used against your employees for asserting their rights under the earned sick time law. Okay, record keeping. What do the employers have to do? Employers must keep true and accurate records of the accrual and usage of earned sick time. Okay, so similar to the rest of your payroll records, you have to keep track of use and accrual of earned sick time. And remember, if you have employees working in more than one jurisdiction, in particular if their primary place of work is Massachusetts, you're going to have to keep track of where exactly they're working, because you're going to want to, because for some of these employees, their primary place of work may vary and over time, and one year they may be primarily working Rhode Island, and another year they may be, and therefore not entitled to earning sick time. Another year they may be working primarily in Massachusetts, and therefore you have to keep track of all of their hours worked and allow them to accrue. Now, you do not have to keep track if you decide, if you have a comparable paid time off policy. If you have a policy in place that essentially says, you know what, you get up to 40 hours, you get 40 hours, or certainly if it's more, and particularly if you front load it, if you say come January 1st, you give all your employees 40 hours of paid time off or sick time. If you do that, if you front load, you will not have to track it. what you're going to want to do is see how much they've actually used. But if you know you're going to front load at the beginning of every calendar year for all employees, then I would track how much time they've used, but you don't have to track their accrual because it becomes irrelevant. You need to maintain these records for 3 years. Like I mentioned before, you must, if they demand it, you must provide the records to the employee within 5 days. There is a notice that the Attorney General's office has up on our website that the employers are required to post everywhere. Everywhere an employee works, you are required to post it, similar to the wage and hour poster. But with regard to contractors, you're going to have to post it both in your main office and anywhere you're doing work, so that all of your employees can see this notice. In addition, the law requires that you provide either a hard or electronic copy of that notice to all of your employees. Okay. You may have substitute policies. We talked about that. As long as you allow your employees to earn and accrue at the rate at which they're allowed to do so under the earned sick time law, 1 hour for every 30 hours worked, or if you front load it, you're fine. You can provide a lump sum of 40 hours at the beginning of the year, or if you have an unlimited sick time policy, you do not have to track accrual or allow any rollover. So you may have a substitute policy, but you also have to make sure that you allow the employees to use it for the purposes that are incorporated in the sick time law, and also that they have job protection status as a result too. Now let's talk about the penalties. There's potentially four different times you may have to defend yourself any time somebody files a claim for unpaid sick time. Number one, the Attorney General's office can come after you. They can come after you for failure to pay earned sick time, or retaliation, or anything else that you did that violated the sick time law. But let's talk about the failure to pay, because that's going to be the central claim. What will happen is that, similar to any other manner in which you may have violated the Massachusetts Wage Act, the Attorney General can issue a civil citation against you that would require you to pay the wages, i.e. the restitution, and any fines that she imposes. You can pay it, you can appeal it to administrative law hearing, or you can ignore it. If you pay it, it's over and done with. If you appeal it to administrative law hearing, you have sort of a mini trial, and the administrative law judge decides if you're required to pay it or not. Or you can ignore it. If you ignore the citation, or if an administrative law judge says you have to and you ignore that decision, then the Attorney General may come after you criminally. So I'd be very careful about ignoring any citation from the Attorney General's office, because she could come after you civilly and criminally. In addition, there is the private right of action, in which employees can sue their employers in private civil court. And if you lose, this falls under the Massachusetts Wage Act, if you lose, the employer is required to pay mandatory treble damages plus attorney's fees plus the cost of litigation. And I can tell you that in the world of law, there is a small cottage industry of lawyers. They are the new breed of ambulance chasers that are going after non-payment of wage cases, because it's a mandatory treble damages as well as attorney's fees and cost of litigation. So I would be very, very careful to want to avoid that. Personally, I think the Attorney General's office is going to, as long as they think that you are attempting to comply, and particularly for union signatory contractors, I don't think she's going to want to get involved with the claims that are subject to collective bargaining agreements. I just don't think she's going to want to go there. But and that comes from having enforced the law in the Attorney General. I used to enforce the law for the Attorney General's office for 6 years, and so I can tell you we avoided collective bargaining agreements because they are governed by federal labor law. So that being said, but I just want you to know that the Attorney General's office can come after you both civilly and criminally. Your employees can come after you for through a private right of action. And then lastly, for those of you who are signatory to collective bargaining agreements, that the employee can file a grievance. And this earned sick time law specifically says that it does not diminish or impair the obligations that are contained within collective bargaining agreements, meaning that this sick time law is your minimum. This is the minimum that you have to do. It's a statutory requirement. but you may have additional contractual obligations under your collective bargaining agreements, and therefore this sick time law is not going to infringe or impair on those in any way. So your employees can file a grievance with the union, and you would go through the arbitration process. And what that means for you is that you would you may possibly have to defend this in 4 different forums, really. And then to follow up, and if there's any more questions that are coming through, please let me know now, because we're going to be wrapping this up in just a few minutes. On the last sheet of the last slide, I have included contact information. Anybody who has any questions after this, I'm sure many of you may be very confused. Feel free to email me or my partner, Jim Grosso, at the emails listed on the slide, or call us in the office, or, quite frankly, get in touch with the Attorney General's office. They are the ones enforcing the law, and they are listening to people. They are fielding questions all the time, and I've included their website on there, and I have included the email address to send them questions, and then Assistant Attorney General Mike Firestone is the person to call. That's his direct number. You can ask him questions directly. So I am at the end of the slide. If I don't receive any more, I'm going to stay on for a few more minutes. I obviously can't hear you folks, but if I see any questions coming in, I will take them. But so far I haven't seen anything else. Oh, wait a minute, I've got one. I'm confused. Employees accrue up to 40 sick hours and then stop accruing. However, if they use sick time and drop below 40, then they begin accruing again. That would make the cap greater than 40 hours, wouldn't it? Yes and no. What that means is that they're entitled to use up to 40 hours in a benefit year, but remember, they can also carry over up to 40 hours. And so they stop accruing, but if you look at the Attorney General's regulations, and it's going to take me a moment to find it, it specifically says that if they drop below, under the accrual section, which is 33.03, if they start dropping below, then they can start accruing again. Okay, so it says under 33.03, 8 and 9, and this is where it becomes complicated. It says once employees have accrued 40 hours of earned sick time during the benefit year, they do not continue to accrue more hours of earned sick time regardless of the additional hours they work. Okay, that seems as if that's it. It's a cap at 40 hours. However, it also says under number 9, once an employee possesses a bank of 40 hours of unused earned sick time, the employer may opt to delay further accrual until the employee draws down the bank of earned sick time to below 40 hours. So then if they start using their earned sick time, they can start accruing again. That's the way I interpret it, that they can start accruing. They don't get to use over 40 hours, but they are entitled to start accruing and therefore carry over up to 40 hours. And it says at the end of the benefit year, an employee may roll over up to 40 hours of unused earned sick time. I would suggest to you that 8 and 9 are a little bit, not contradictory, but unclear, and that you could go to the Attorney General's office just to be clear, that because I could see an employer making the argument that once the 40 hours have been accrued, they're not going to be tracking again until the next calendar year. But Section 9 is a little bit vague about that, and I would suggest that that you could ask the Attorney General's office directly. You know, can I stop tracking accrual once the 40-hour max is met, regardless of how many hours the person has actually used? So if I don't see any, oh, one more. What if the employee does not have a doctor to get the note from? Then the law says the employee can write his own note, which is a little bit pathetic, but that's allowed. So, but the employee can verify his own sick time leave, and that is meant for that very small segment of society that does not have a doctor. You know, if the employee went to a healthcare center, went to anybody, a clinic, a hospital, they should be able to get a note from that person if it's required. In the unlikely situation that they do not have a doctor. Okay. Is your example of heavy drinking by Patriots fans based on the anticipated and high probability of woeful performance of the team in the coming 2015-2016 season without one-star player at the key position? Who says he's not going to be playing? And I think number one, the jury isn't out yet, right? Isn't it his fate still up for grabs since he appealed it? And number two, who says they won't win? Who says, who says we're going to lose? You never know. But I appreciate the question. All right, so now that we've been on for an hour, I think it's time to hang up. If any of you have any questions, feel free. Again, email me, give me a call. Bear in mind I'm getting bombarded with questions, but I will try and field them all. And I hope you enjoyed this seminar. It's a little bit tricky to do it over the phone. It's a little weird not seeing the audience, but I thank you all for your time and participating.